in connection with a trial award. Wasn't there a study made in San Diego County in regard to that at one time?
Well, that's probably we'll talk about a little more when we get down to trial de novo, but it is true that in the personal injury field, the expertise of the arbitrators is such that the amount they come in for on the award are very closely reflected in the judgments in cases that have gone to trial de novo. In other words, the first experience are that it's uneconomic to have a trial de novo in a case where there really isn't a big difference of opinion as to the value of the case, and that the high quality of arbitration will continue to make it uneconomical to do so. In other words, there's no sense having an arbitration coming in for $3,500 and then going to trial de novo and have the jury come in for $3,250 after a 5-day trial. There's just no sense in that. And as long as the quality of arbitration remains where it is, it seems to me that trial de novo feature is going to be kept in hand.
Before we get away from depositions, let me mention two other items with reference to them. If you follow 1613B3, you can get your depositions in. You might be able to get them in other ways. As I said, the CCP 2016 objections are reserved. You may also subpoena a deponent in to the hearing. And if you do so, it's as if you were subpoenaing that deponent into a trial. You're going to have to serve them with a witness fee and what have you. You may then examine the deponent. The arbitrator has the option of either excluding the deposition or of admitting the deposition and allowing the deponent to be further cross-examined, depending upon what the arbitrator feels would be fair in that particular instance. Now, let's say that the deponent doesn't show up and you've subpoenaed him. The arbitrator has the power to continue the hearing. You then will go into court if you so desire and get an order to show cause and handle it as a contempt proceeding. The arbitrator himself will not handle it as a contempt proceeding. You're going to have to move in court for that. I think basically that covers really a great deal of 1613 and the exceptions to the rules of evidence.
Well, having conducted the hearing and getting all the information to the trier of fact, the arbitrator in this case he has an opportunity to reflect and then make his award. And the stress is placed everywhere in practice that this award should be promptly made. Rules say 10 days unless an extension is given of 20 days in a complicated case. But there's very little reason why there ought to be any delay in getting the awards out. Certainly in the personal injury case, where the award would typically only set out the amount of the damages and the cost. The arbitrator doesn't have to make findings. There's no need for any kind of an elaboration. And in fact, the form in the materials shows you just how simple his award can be. Whether that's going to continue to be possible in a very large number of percentage of cases, as the mix of business changes under the new statute and rules of court, remains to be seen. I think some business cases won't be capable of that, just sort of a numerical disposition of the litigation. But that's still in the future, and there's been no experience gathered yet to cast much light on the path ahead. The arbitrator has a very limited time to amend his award. He can amend the award only during the same period of time they had to make the award, the 10 days. And as I say, the contents of the award are simplicity itself in a personal injury case, and what they may be in the future remains to be seen. Now, once the award is in,
Alex, I'm sorry to interrupt you, but I would like to ask you a question that I probably haven't asked you before, and I'm not sure whether you can answer it or not. It was posed to me by someone on the phone just the other day. The arbitrator was hearing a personal injury case. It took most of the day, although there were still a couple of hours left in the afternoon. And he adjourned the hearing at that point because some points of law had been raised that really needed to be covered by briefs. He's given the parties 15 days to submit briefs on the point of law, and he's permitted response briefs and what have you. And he was a little concerned about the fact that the award has to be in 10 days after the hearing. And the position that he adopted was that, in fact, although he started the hearing on a particular date, he was now continuing the hearing to a later date in order to permit further argument by way of brief and further evidence as necessary. He thought that perhaps that way he wouldn't run afoul of the 10-day time limit. The interesting thing is that he also brought up a second question. My first question is, does that sound like a legitimate way of handling a complicated case? And the second question was, he said, I've already spent almost a full day on this. I'm going to spend at least another 2 or 3 hours reading their briefs, and from some of the expert testimony on this particular issue, I think I'm going to spend another 2 or 3 hours in the library doing research of my own. Does it sound to you like I am justified in billing for 2 days of hearing? And that's the second question.
Well, I don't think there's any problem about the first question. You, Norm, I think he has some more material to collect on the case that hasn't been concluded as far as the hearing phase goes. As to the second part, the charges now for arbitrator service are between the arbitrator and the county.